everyone knew it as Donald Trump's standard catchphrase.
You're fired.
And it's the one that has stayed the same from the boardroom to the White House, as President Trump has tried to reshape the federal government, firing civil servants.
After a lifetime of unelected bureaucrats stealing your paychecks, attacking your values, and trampling your freedoms, we are stopping their gravy train, ending their power trip.
Including firing the heads of the nation's independent regulatory agencies.
You're fired. Get the hell out of here. You're fired. Get out of here.
One agency in particular has been the president's primary focus, the Federal Reserve.
In my case, I made a lot of money. I was very successful, and I think I have a better instinct than, in many cases, people that would be on the Federal Reserve or the chairman.
The traditionally independent central bank has faced mounting criticism from President Trump for not lowering interest rates, and it all came to a head last summer.
President Trump taking his pressure on the Federal Reserve to a new level, firing Fed Governor Lisa Cook in a social media post.
Lisa Cook was one of 7 on the Federal Reserve Board of Governors serving a 14-year term. The president said he was firing her over allegations of mortgage fraud, allegations she denies. And here's why that's important. Under federal law, presidents can only dismiss Fed governors for cause, meaning actual evidence of wrongdoing.
Cook responding, President Trump purported to fire me for cause when no cause exists under the law. I will not resign.
So, can the president do that? And who else can the president fire? These are some of the questions before the Supreme Court right now in not one, but 2 major cases, Trump v. Cook and Trump v. Slaughter. I'm Laura Jarrett, senior legal correspondent at NBC News, and welcome to Here's the Scoop Supreme Court Edition. I'm spending this month speaking to legal experts and attorneys whose legal wins make up the building blocks of the current cases before the High Court this term. Attorneys like Cannon Shammigan, head of the Supreme Court and appellate practice at Davis Polk. He's argued the last major Supreme Court case about presidential power and independent agencies back in 2020, Saylor Law versus the Consumer Financial Protection Bureau.
The structure of the CFPB is unprecedented and unconstitutional. Never before in American history has Congress given so much executive power to a single individual who does not answer to the president.
And Cannon joins me now. Cannon, so nice to have you here in studio.
It's great to see you, Laura.
You clerked for Justice Scalia some 30 years ago, and you basically have not left the court since then. In fact, you have argued some 40 cases now in front of the Supreme Court, which has to be some sort of world record.
Oh, I don't know about that, but it is true that I have basically since day one of my legal career had a practice that focuses on the work of the Supreme Court.
Do you have a favorite case, or is that like picking a favorite son?
That would be like picking a favorite son. So I only have 3 sons. I don't have 40, but there's something about every case that is special. And the case we're going to discuss today was special simply because it was so important.
Well, let's get to it. The year is 2008. The country is in a financial crisis.
On the broadcast tonight, meltdown. The American financial system is rocked to its foundation.
These charts we're going to look at, they are worth more than $1 trillion in losses. The Dow free falling by 7%.
A crisis of confidence on Wall Street.
In response, Congress passes the Dodd-Frank Act to reform financial regulations, and as part of that legislation, it establishes the Consumer Financial Protection Bureau, fondly known as the CFPB, as we're going to refer to it today, just for ease and for shortness. And the point of the CFPB was to protect consumers from predatory lending. So back in 2017, the CFPB started this investigation of a company called Saylor Law that provided debt relief services to clients. The CFPB says it's trying to see if Saylor is violating rules around telemarketing sales. But the firm refused to comply with their demands, and it actually turned the tables on the CFPB, arguing that the agency's very design violates the Constitution. How so? Through separation of powers, it says. When did you first get involved in this case?
Well, it was after the Court of Appeals, in that case the Court of Appeals for the Ninth Circuit, which covers the West Coast, issued its decision, and it rejected the constitutional challenge. So our client, Saylor Law, was seeking to obtain review from the Supreme Court. And it was at that point that I spoke with Tony Bisconti, who is the wonderful lawyer who had handled the case in the lower courts. I think Tony thought that it would be in the client's interest to have an experienced Supreme Court litigator try to get this case to the Supreme Court. And there was no guarantee that the Supreme Court was going to hear this case, but this was one of those issues that had been floating around really ever since the CFPB was created. I think there was a lot of question about whether or not the structure of the CFPB, which was relatively novel, was constitutional. It was an issue that I was familiar with, and so we were very happy to work with Tony and his law firm, first to get the Supreme Court to hear the case and then to handle the case after it did.
You say it was sort of a point of discussion at the time, but it really was sort of a boogeyman for conservatives, right? They thought that the CFPB was unconstitutional, the way it was set up with a single director who could be there for 5 years, not of the president's choosing, perhaps going completely against the president's agenda. Was any of that part of the backdrop to how you decided, sure, I want to take on this case?
You know, I try really hard when I decide whether or not to take on cases to kind of put my personal views aside. I never think, if I were a judge, would I rule in favor of this client? I just thought that this was a very important and substantial constitutional question. And you're absolutely right that there were questions about the CFPB even from the moment it was created. Congress's very goal in creating the CFPB was to insulate it from political control. And the whole point of our constitutional argument was that when you have an agency that is exercising executive power, the president has to have the ability to control who's going to be in charge of that agency and to remove that person for whatever reason.
What was the goal of this case? Because on the one hand, if your client just wanted to avoid turning over documents and information, they could have gone about that a whole bunch of ways, other than making sort of this broad constitutional argument. So what exactly was the point of this case?
Well, the point of the case was really to get our client out from having to produce the documents. It was not to make some new highfalutin law. It was to win for our client. And our client had made a number of different arguments as to why it did not have to hand over the documents. Those arguments did not succeed, but Tony very wisely included this constitutional argument. And that was our ticket to get in the door at the Supreme Court, because the Supreme Court, as you know, doesn't grant review just to decide cases. It grants review to decide important legal questions, questions that matter to the country. And this constitutional question was obviously one of those.
And what was the main thrust of your constitutional claim?
The main thrust of our argument was that when you have the head of an agency who is exercising executive power, and the issuance of a civil investigative demand, basically a subpoena, is one example of that, the president has to have the ability to control that individual through the power of removal. And what Congress had tried to do, one of the many things that Congress tried to do to insulate this new agency, was to say that the director could only be removed for cause. Now, there's some debate about what that means, but the basic idea is that the president would be limited to removing someone for engaging in acts of malfeasance, such as criminal activity and the like. And our argument was that that limitation was unconstitutional and that that was a structural problem with this agency under the Constitution, that violated the separation of powers by taking away a core presidential power.
Put the CFPB to the side for one moment and just talk to me about theory around executive agencies. And say your youngest child came to you and said, "Dad, I don't understand, why do I need to care about these executive agencies," right? We learn about the president, we learn about the judiciary, we learn about lawmakers in Congress. What are these executive agencies, and why do I care what they're doing?
Well, our youngest child is 9, but he's very precocious.
I picked him in particular.
So I will start with how Henry would have thought about this and what he would have asked. And I think the answer to that, if you think about this in terms of Schoolhouse Rock and sort of basic principles of our government, the basic idea is that it's Congress's power to make the laws. It's the president's power to carry out the laws. When we talk about executive power, we're really talking about executing the laws, carrying them out. And what took place in the early 20th century was that Congress started to create so-called independent agencies. And what it was really trying to do was to kind of have it both ways. On the one hand, to say that these agencies would do things that you would think of as exercising executive power, things like bringing enforcement actions against individuals and private parties, issuing regulations, and here issuing civil investigative demands. But yet Congress at the same time tried to make these agencies independent, tried to take them outside the executive branch. And Congress has done that in a variety of ways. But I think this issue of removal has really become the flashpoint for a lot of this litigation. And the reason for that is pretty obvious. It is that you can very easily imagine a scenario, and this was true with the CFPB, where you have the president of one party picking the person who's in charge of the agency, but then you have an election, and then you have a president of the opposite party coming into office, and you've got a complete misalignment in policy priorities between that person who is inferior to the president and the president himself or herself.
Why is that not a good thing for democracy?
Well, the argument was that that was a good thing as a matter of policy. And the argument on the other side was whatever the arguments about policy, and I think there are good policy arguments on the other side, that was simply not the structure that the founders envisioned, that the founders really envisioned that we would have an executive where anyone who is exercising executive power is doing so effectively as an agent of the president. Now, that isn't to say that there are no limits. The Constitution itself requires that executive officials of a certain level of seniority be confirmed by the Senate before they can take office. That is a very real check on the president. The president can't just pick whoever he or she wants. But those limits are in the Constitution. And beyond that, our basic submission was that the structure of the Constitution meant that the president had this power.
Let's set the scene on the day of the arguments, Cannon. It's March 3rd, 2020. There aren't huge crowds of protesters outside, but that doesn't mean there wasn't an audience inside for you. In fact, there's some heavy hitters inside. You have Leonard Leo, the former head of the Federalist Society, someone who has had a fair amount of attention and influence in advising Republicans on who should be on the Supreme Court itself. You also have Mick Mulvaney, the president's then chief of staff and former head of the CFPB. You also have former Senator Chris Dodd of Dodd-Frank fame, the law that set up the CFPB, and you have Maureen Scalia, the wife of the late Justice Scalia, for whom you clerked, and also the two other attorneys there arguing the case. So it's basically like a Scalia homecoming at this argument. Before you even step up to the mic, Cannon, you know that these justices have a record when it comes to executive power. Justice Kavanaugh has been very clear about his feelings on the dilution of presidential power. Justice Gorsuch, Justice Alito, they've all made their feelings on this clear. So you must have gone into arguments feeling confident. But was there anyone on the conservative side that you were actually worried about?
I would say that the justice about whom we had the most doubt was actually the Chief Justice, who had written some opinions in the area that were broadly favorable to these types of challenges, but that had stopped short of going as far as we needed him to go in order to provide the potential fifth vote for us. And so as I was thinking about the argument, I was doing something that I don't usually do, which was thinking a lot about how we would frame the argument in a way that would be appealing to him. Recognizing that we couldn't take anyone for granted, but that if we were going to get to 5 votes, he was going to be kind of like the electoral equivalent of Pennsylvania. He was the one we really needed to get.
I want to talk briefly about another oddity of this case, which is the Trump administration's position on the CFPB. Because typically, the Justice Department is there to defend federal agencies, right? That's its job. They're basically like the law firm for the federal government. Here, the Trump administration is not, shall we say, vigorously defending the CFPB's structure. What was the Justice Department's position, namely Noel Francisco's position as the Solicitor General in this case?
So the Justice Department supported our position, at least on the core constitutional question. There were also some questions about what to do if the structure was unconstitutional, and there we actually had some disagreement. But on the constitutional question, they were basically aligned with us.
That the president can fire the head of the CFPB.
Yes, and I would say that that was not as surprising as it might seem. The Solicitor General ordinarily defends the constitutionality of federal laws. That's kind of part of the job description. But at the same time, when questions come up concerning executive power, the Solicitor General is both the United States' lawyer in the Supreme Court, but also the president's lawyer. He is a member of the executive branch. He is there in part to vindicate the interests of the executive branch. And the president took the position that he should have the power to fire the director of the CFPB. And as you said at the outset, that is a position that I think conservative and Republican presidents have taken fairly consistently over time. So I wouldn't say it was a surprise that the Trump administration came out that way.
Your client, Seila Law, was under investigation by the CFPB, as we mentioned, and you're arguing that the structure of the agency itself is unconstitutional. But you are not quite writing on a blank slate when it comes to the law in this area, and you have to wrestle with a decision from the 1930s in order to get where you want to go.
Yeah, so there were two key precedents in this area, and they are important enough precedents that I remember reading them in law school. One is a case called Myers, and the other is a case called Humphrey's Executor. And those were cases that pointed in opposite directions. Myers stood for the broad principle that the president has the power to remove inferior officials exercising executive power. Humphrey's Executor was a case that upheld restrictions on the removal of members of the FTC, the Federal Trade Commission. The commissioners of the FTC are the people who run that agency. There are 5 of them, so it isn't a single director like the CFPB. But the court, in its opinion in that case, said that when it came to these so-called independent agencies, Congress could impose certain limitations. So the whole case really boiled down to whether this fit within the Myers principle or whether it fit within what we viewed as the Humphrey's Executor exception.
There's a ton of discussion, especially early on in the oral argument in Seila, in your case, about the single director issue of it.
That a multi-member commission, just because it diffuses power, is much more difficult to influence. If a president can get one person on the phone, that's a lot easier than if he has to worry about 7 people who are all doing their own thing. And so in just the basic understandings of one person, easy to influence, more accountable, even if you can't influence him, you can point at him. Why isn't a single-member agency better?
Why is that such a big deal, do you think? Why was that so top of mind for the justices, that the CFPB has this single director who can be there for 5 years without the president being able to get rid of him for whatever reason he wants?
I think it was a big deal because I think that the court at the time was perhaps more concerned about whether a ruling in our favor would require it to overrule Humphrey's Executor. And we were certainly giving the court the option of writing an opinion that essentially said very little about Humphrey's Executor.
If the court does not accept that distinction, then I think it is squarely presented with the question of whether to overrule Humphrey's Executor. But we don't believe that the court needs to reach that question.
And the reason you do that is because if you can manage to get the court to not have to overrule itself, you think that always endures to your benefit?
Yeah. I mean, I think we basically thought that if we could make the omelet without breaking eggs, that we would prefer to do it that way. We wanted to give the court the most minimal way of ruling in our favor and giving our client the relief that it needed. And in the end, that's why I think the court was so focused on that issue.
On the removal of power in particular, one of the things that some of the liberal justices keep coming back to is this idea of these agencies deliberately being set up to be insulated from political power and political influence, and that they're set up that way for good reason because they're agencies that do things that we care about, like enforce labor laws or oversee consumer safety. Listen to Justice Kagan on this point.
Removal has historically been very difficult for presidents to exercise as a way of controlling people because the people you want to remove the most, there are all kinds of political constraints about why you shouldn't remove them. So removal is like a nuclear bomb.
What's your rebuttal to Justice Kagan?
I think the response to that really is that that's the whole point in some sense, that if these agencies are deciding truly consequential policy issues, they should be subject to the control of the president. And, I'd be the first person to recognize that if you were setting up a system of government from scratch, you might decide that you want to allocate more power to people who are not democratically accountable, to people who operate in bureaucracies. You could make that judgment as a policy matter. Our basic view was that that was not the judgment that the founders had made, that the founders had made the judgment that anyone who exercises executive power has to be accountable to the people ultimately through the president, who, of course, is elected.
That argument was persuasive to 5 justices. You won, and the court did end up ruling that the president could fire the CFPB director at will, but the agency remained intact. In his opinion, the Chief Justice wrote this: even assuming financial institutions like the Federal Reserve can claim a special historical status, the CFPB is in an entirely different league. And he goes on to explain some of the ways in which the CFPB in particular is different. It's sort of acting as a quasi-prosecutor and court. It has all of this power. But the part about the Federal Reserve is the part that people are now really cued in on. What do you think it is about the Federal Reserve that this court finds different than any other federal agency?
I think it's the context in which the policy arguments are the strongest for insulating the agency from political control. And the court, both in the Saylor Law opinion, at our instance, because we dropped a footnote in our brief that basically suggested you might want to treat the Federal Reserve and financial regulators differently. But both in that opinion and in subsequent opinions, the court has reiterated that there's something different about the Fed. And the court has traced that back to the original Bank of the United States. These are entities that have had a distinctive status in many respects. But I think that when you boil it down, I think that that is the context in which there is the most concern about presidents exercising political power in a way that could be disruptive of the financial markets and have other unfortunate consequences. And that now is effectively treated as settled law. I think even if the Supreme Court ultimately concludes that the principle of Saylor Law sweeps quite broadly, I don't think anybody thinks that the court is going to extend that principle to the Federal Reserve.
Cannon, there are 2 cases before the court this term that involve the president's ability to fire people, the precise issue that you confront in Saylor Law. Before we get into the laws, I want to talk about the theory that is really serving as the undercurrent here, because it is a term that got thrown around a lot, I would say, in the past couple of years, and it used to be sort of relegated just to law classrooms, and it's known as the unitary executive theory. What is that?
I think that the label unitary executive has been used as a shorthand for any argument that the president should exercise control over the entirety of the executive branch over individuals exercising executive power. And I think it is fair to say that that is a theory that has been advanced by conservative jurists over the years. But here we really are talking about the power to fire people in the government who are exercising executive power on the theory that those individuals have to be directly accountable to the president.
So it's a theory that President Trump has not named as one that he subscribes to, but in practice, that is what is happening. So in August of 2025, the Trump administration accuses Lisa Cook, a member of the Federal Reserve Board of Governors, of falsifying bank documents to get more favorable loan terms, claims that she has denied. The president posts a letter on social media citing, quote, his authority under Article 2 of the Constitution of the United States, adding that he had sufficient cause to remove her. She sues, saying that this violated the law, which says the president can only remove a board member for cause. And she says her due process rights were violated because she didn't get to defend herself before he blasts out that letter on social media. Why is this case, given those 2 arguments, not a slam dunk for Lisa Cook?
Well, I think what makes the Cook case interesting is that the Federal Reserve has been treated differently. The Supreme Court has indicated that unlike other federal agencies, the president really does have to have cause before he can remove directors, governors of the Federal Reserve.
And cause meaning real evidence, real tangible evidence of wrongdoing, not just some rumor.
Well, that's the question, is what does that mean? It's a concept that has been around in the law for a long time, this concept of removal only for cause. But there's no definition of that, and courts really have not put a lot of meat on the bones of that phrase. And so one of the questions before the Supreme Court in that case is, what does cause mean? And how does a president go about removing someone for cause? Does the president have to hold a hearing? What sort of process does the president have to provide? It's a little bit harder to predict where the court is going to come out, precisely because you don't have a lot of evidence as to how these individual justices feel about it.
And does the Supreme Court really want to be down in the muck of the record trying to figure out whether his social media posts had enough to constitute cause? That doesn't really seem like an issue befitting the high court.
I think what was interesting about the oral argument in that case was that there was definitely some sense that presidents should get some degree of deference in making these determinations. But where exactly to draw the line, I think, is what the court was really struggling with.
This is not a question about what the standard is. It's more a question about, is there a kind of deference to give to the president? How does that deference operate, whatever the standard is?
And there's both a substantive question and a procedural question. The substantive question is, what constitutes cause? And then there's just the question of whether the president has to provide, for instance, some form of hearing, some opportunity for the
due process issue.
And that's the due process issue.
Why couldn't those resources have been put into a hearing? I understand you think that you don't have to provide one, either because of the statute or because of the due process clause, and that's fine. But in thinking about irreparable harm to the government, if one step you could take to reduce your irreparable harm, to show that there really was cause, is just to have a hearing, why not?
We've talked about the ways in which the court has signaled that they are treating the Fed differently. But there's also a suggestion from Justice Kavanaugh that essentially what goes around comes around.
Well, history's a pretty good guide. Once these tools are unleashed, they are used by both sides, and usually more the second time around.
What I hear Justice Kavanaugh saying there is, if we say it is okay for President Trump to fire this person, then we have to be willing to say it's okay for the next president to do it too.
I think that the court was keenly aware of that. I think that there is a recognition that if you give the president broad power in this area, what president would willingly refuse to exercise it? I think given the way many of these agencies are structured, where almost by design the agencies are structured so that they have bipartisan membership. They have both Democratic appointees and Republican appointees. Any president who wants to get their policy priorities implemented is going to have a very powerful incentive to exercise the power to remove right away. Indeed, in Selah law, the primary beneficiary of that decision was not President Trump, it was President Biden, who very promptly removed President Trump's head of the CFPB after he took office. So unlike a lot of other issues that are being litigated right now that seem to be specific to the current administration, this is a set of issues that is going to have long-term consequences for the way that our country operates.
The other case on their plate is Trump v. Slaughter, and in many ways it more closely tracks some of the issues that you were grappling with in Selah. In that case, despite having nominated Rebecca Slaughter to serve as the commissioner on the Federal Trade Commission, President Trump tries to remove her in March of 2025, saying her continued service on the FTC is, quote, inconsistent with my administration's priorities. Basically, like, I just don't want you around anymore. I don't really have to give you a reason other than it doesn't work out for me. He again cites his authority under Article 2 of the Constitution. She sues, but has a slightly different legal hook than Lisa Cook. She points to federal law, and it tracks the very same language as the one at issue in your case that says the president can fire a commissioner only for inefficiency, neglect of duty, or malfeasance in office. So it doesn't say cause, but essentially it says, like, you got to mess up. We can't just fire you because we don't like you.
Yeah, so I think that this case is the more consequential of the two, because this case really affects all of the other agencies. The Lisa Cook case is really specific to the Fed because the Supreme Court has indicated the Fed is being treated differently. This case potentially affects all of the multi-member commissions like the FTC, the FCC, the SEC that you see lining the streets in Washington, all of those agencies are structured relatively similarly. And this is the question that was looming in Seola law, which was whether or not a ruling in favor of our client would have a similar effect on all of these other agencies as well.
How do you think your case differs from Slaughter's case, except for the fact that you were dealing with a single director and this is a multi-member agency?
So that would potentially be the difference. But in the opinion in Seola law, the Chief Justice writing for the majority articulated the constitutional principle as one that would apply whenever you had an official who was exercising substantial or significant executive power. And even at the time the court issued that decision, it seemed pretty clear that the court was not willing to say that multi-member commissions would be treated differently, that the court was instead articulating a principle that could potentially apply across the board. President Trump, I think, probably taking a cue from that opinion, removed many of the Democratic appointees on all of these commissions, really setting up this litigation to test the reach of the Seola law principle.
So knowing that the argument that if Slaughter can be terminated essentially for no reason at all, that means huge repercussions for all of these other independent agencies, as you outlined, Justice Alito asked the Solicitor General to address that directly. Listen to this.
It's been suggested that if we were to rule in your favor about the Federal Trade Commission, put aside these other agencies, just about the Federal Trade Commission, which is the issue that's before us, the entire structure of the government would fall. You want to take a minute to address that?
Anytime a justice says, you want to take a minute to address that, it's really not a question. It's a statement because he's essentially saying, please address that for other of my colleagues on the bench who care about the answer to that question.
Well, I wish a justice would sometimes give me a minute to answer a question. That actually doesn't happen very often in the Supreme Court. But I do think that that was probably a friendly question to the Solicitor General to explain the consequences of
because
a
Alito doesn't
ruling.
think the government's going to fall apart if this happens.
I assume that he won't at the end of the day and that he will vote, I think, probably with the majority to say that the president does have this power. Now, what makes this case interesting is that it involves the FTC, the very agency that was at issue in the Humphreys Executor case, the earlier precedent in which the court had said that restrictions on removal were permissible. And so I think that the court really is going to have to confront that earlier precedent. But I think in some sense the court largely did that already in Seola law when it essentially limited Humphreys Executor and said, we're going to focus instead on the amount of power that's being exercised, not the shape of the agency and whether or not it's a commission.
The liberals, as you might imagine, have plenty of pushback about this idea of the president being able to fire the heads of these independent agencies for any reason at all. Here's Justice Sotomayor and Kagan.
I think neither the king nor parliament nor prime ministers, England at the time of the founding, ever had a unqualified removal power.
So the result of what you want is that the president is going to have massive, unchecked, uncontrolled power, not only to do traditional execution, but to make law through legislative and adjudicative frameworks.
They're in the minority, but do those types of arguments have any purchase with the Chief Justice such that you might have a more narrow ruling at the end of the day on this case?
I think that in this case, I do think that the administration is likely to prevail. And I
on
think
Slaughter.
On Slaughter, yes, that's right. I think that it's entirely possible that those two cases could come out in different directions.
Yeah.
In fact, I think a lot of commentators have suggested that that is the most likely outcome. I do think what will be interesting if the administration wins is to see what happens next. I think there are a variety of things that Congress could do in terms of how it structures agencies. If you have agencies that exercise legislative powers or adjudicative powers, as Justice Kagan said, you could split those powers off And as long as those powers are not executive powers, the agency could exercise them in a structure where the heads of the agency are insulated from presidential control. And so I think that the final chapter has not yet been written in this area. And there's no doubt that this is going to set very different ground rules going forward. Again, I would expect that whenever there's a change in administration, the presidents will exercise this power pretty muscularly because it is a way of implementing preferred policies in all of these areas where these agencies have considerable control.
Can we end by going back to your son, Henry?
Sure.
How would you explain to Henry how his life would change in like a real tangible way if the Supreme Court says Trump can fire Lisa Cook, he can fire Rebecca Slaughter?
Well, I don't think Henry's concerned about interest rates yet.
Well, you never know. He is quite precocious.
Unless he has some sort of secret mortgage that I'm unaware of. These are really important principles that I think we probably don't think enough about. You know, when I think back to learning about the Constitution, not in law school, but in high school or in college, we focus an enormous amount on the Bill of Rights, and with good reason, because the first question that anyone has is, what rights do I have as an American citizen? The right to free speech, the right to be free of searches and seizures, unreasonable ones, the right to a jury trial. But really, the first part of the Constitution is not the Bill of Rights, which were the amendments. They are the 3 articles of the Constitution that set up our governmental structure. And so these questions are really important and fundamental, and your average person on the street probably doesn't spend a lot of time thinking about the limitations on Congress's power or the scope of the president's power in various respects. But in terms of the day-to-day functioning of the government, you know, what is the government's antitrust policy going to be? How does the government approach questions of competition between businesses? How does the government regulate the securities markets? These are all questions that are going to be affected by the outcome of these decisions. They may not matter in ways that affect the daily life of a 9-year-old, but they really matter for how our country operates.
Cannon, thank you for being here.
Thank you, Laura.
That's a series wrap on Here's the Scoop Supreme Court Edition. In case you missed it, I've been talking to lawyers and legal experts all month long about the precedents that make up the building blocks of the cases before the Supreme Court this term. We've covered birthright citizenship, trans women in school sports, and geofencing. Be sure to go back and check those out right here in the Here's the Scoop feed. Our show was produced by Abigail Brooks and Amanda Llewellyn. Erica Kwong engineered with support from Jessica Fenton. Our video editor is Jacob Condon. Kinteri Yoakum is executive producer of Here's the Scoop. And Shalini Sharma is the senior vice president of content development at NBC News. I'm Laura Jarrett. Thanks so much for listening.
We thank you for watching, and remember, stay updated on breaking news and top stories on the NBC News app or watch live on our YouTube channel.